Negotiable instruments, legal tender, and debt payment claims in U.S. law. 1. Purpose and framework. You evaluate claims about creating money with signatures, the status of Federal Reserve notes, and the use of endorsements on bills or loan papers, and you align those claims with controlling constitutional and commercial law sources. Footnote. You use authoritative text to separate legally operative rules from popular misunderstandings. 2. Legal tender versus money definitions. You distinguish constitutional language from statutory tender rules. Article 1, Section 10 restricts states and does not bar Congress from authorizing paper legal tender. Under 31 United States Code Section 5103, you treat Federal Reserve notes as legal tender for all debts, public and private. Dictionary entries may discuss gold and silver, yet statutory tender controls modern payment obligations. Footnote. You apply the federal legal tender statute rather than 19th century usages when assessing what discharges debts. 3. Scope of Uniform Commercial Code. Article 3. You recognize that Article 3 governs negotiable instruments and excludes money. A negotiable instrument is a signed writing that contains an unconditional promise to pay or an unconditional order to pay a fixed amount of money. You do not assume every invoice or monthly statement is an instrument because many consumer bills lack the drawer-drawee-payee structure and the unconditional order required by statute. Footnote. You test any document against the Article 3 elements before treating it as a negotiable instrument. 4. Notes, drafts, and the banking balance sheet. You classify a promissory note as a promise to pay and a draft or bill of exchange as an order to pay. You understand that national banks are barred from lending against their own stock under 12 United States Code Section 83, not barred from extending credit. You avoid conflating Section 16 of the Federal Reserve Act or 12 United States Code Section 412 with a consumer ability to obtain reserves by endorsing retail paper. Reserve bank note issuance and discount window collateralization operate between regulated institutions, not through private endorsements on household bills. Footnote. You keep central bank note issuance and commercial lending mechanics analytically separate. 5. Endorsements and allocation of liability. You differentiate a blank endorsement that makes an instrument payable to bearer from a special endorsement that identifies a payee. You understand without recourse language disclaims endorser liability to subsequent holders but does not obligate a creditor to accept a writing as payment or to credit an account. You recognize that altering consumer bills with pay to the order of formulations does not compel extinguishment of debts. Footnote. You treat endorsement form as a liability allocation device and not as a unilateral payment mandate. 6. Claims of debt discharge by endorsement. You evaluate assertions that you can satisfy loans or utilities by writing special endorsements to yourself and directing a lender to obtain funds. You compare those assertions with governing tender law, cardholder and loan agreements, and Article 3 enforcement rules. You note that courts routinely reject homemade instruments and fictitious obligations and that misuse risks civil liability and criminal exposure under fraud and counterfeit obligation statutes. Footnote. You avoid schemes that courts have treated as ineffective or unlawful methods of payment. 7. Lawful avenues to reduce obligations. You proceed lawfully by disputing inaccurate trade lines under the Fair Credit Reporting Act, negotiating extensions or forbearance, refinancing with inability to repay, invoking billing error procedures under the Truth in Lending Act, and using Uniform Commercial Code defenses only where statutory elements are met on an actual negotiable instrument. Footnote. You rely on consumer protection statutes and contract remedies rather than improvised payment instruments. 8. Practical conclusions for compliance. You treat Federal Reserve notes as legal tender under federal statute. You reserve Article 3 analysis for true notes and drafts that satisfy statutory elements. You do not expect endorsements on ordinary invoices to eliminate debt. You engage creditors through agreed payment channels and maintain documentation that would satisfy a court or regulator. Footnote. You ground payment strategy in enforceable statutes, authentic instruments, and documentary evidence.